This is Attorney Eric Bolves. This is an edited version of a 7-hour seminar that I did, which was designed to help teach other attorneys how to file bankruptcy. Hopefully you'll find a lot of the content helpful. There is a much shorter version of this, only about 20 minutes long, that is also available. If you have any questions on any of this, don't hesitate to give me a call at 407-894-1002.
All right, let's get into the nuts and the bolts of Chapter 7 and Chapter 13. Section 2, Chapter 7. Now, getting back to the basics again. Bankruptcy is relief from debt. That's the whole purpose of it under our system. The bankruptcy code that we have helps the debtors administer their debt or take care of their debt. And it has to be fair to the creditors too, but the focus is really relief for debtors. We have the automatic stay, the protection in the court. Let's see here, that's correct, yeah, protection from the court, and the resolution of it is a distribution to creditors of non-exempt assets and the discharge. Okay, under the rules, under uscourts.gov, you can find that a Chapter 7 entitled Liquidation contemplates the orderly court-supervised procedure by which a trustee takes over the assets of the debtor and reduces them to cash and makes distributions to the creditors subject to the debtor's right to retain certain exempt property and the rights of secured creditors. So the idea here is that if you're filing a 7, you're saying, here it is, trustee, except for this stuff. And you have to specifically enumerate what stuff you claim you have a protection on. Because if you don't, the trustee can go get it. I have seen cases, and I call these expensive, cheap bankruptcies, where a person will go in pro se, or they'll go in having their forms filled out by a paralegal who is just a form filler. You know, paralegals, at least in the state of Florida, aren't even supposed to tell you what goes on what line, because that would be providing advice. So sometimes, in fact, I have seen this where people would go in and they have all this property, and they assumed because their brother in Michigan told them that that was exempt, that there would be no problem. And they lost stuff. I've even seen people lose houses because of it. Because they didn't want to spend the money to hire an attorney, and because of it, it became very expensive. Now, probably in most of these cases, they later went out and hired an attorney, filed an amendment very quickly, and got it fixed. I'm hoping that's the case. But the idea here is that a 7 is a liquidation of debts and assets, and unless you have your protections in place for the assets and the property that you want to protect for your client, the trustee will liquidate it. That's the idea of a Chapter 7. So who's involved in the case? Well, the debtors, obviously. Now, a debtor can be a natural or a legal person. So it could be, your client, the flesh and blood person, or it can be the client's corporation. You can be hired by a corporation to liquidate. I see that happen every once in a while. There's an ongoing company. It's just too much. The debts are just out of control, and you file a bankruptcy to liquidate the property. Generally, the only time I see it happening in Central Florida is if you're filing something that might have some assets, like maybe inventory, a car lot, a retail store. A lot of times, most of this stuff is secured, and you can get away with just filing an individual Chapter 7 for the property, for the business owner. But corporations can file Chapter 7s. The idea is that everything will be taken from the corporation. It is possible to file a Chapter 7 and have the corporation survive the Chapter 7, although with no assets. I see that happening sometimes, but the idea here is that if you file a Chapter 7 for a corporation, You have to walk in there with the assumption that the trustee is going to take it completely. Creditors. Any natural person or legal entity who has any type of legal claim in existence on the date the case is filed. And that can be a credit card company, that can be someone in the middle of a lawsuit, that can be someone who has been injured and has not filed a lawsuit yet. If they have the ability to make a claim, then they are considered a creditor. Sometimes people won't think of an individual or a company as a creditor. They'll, it's not clear to them, well, okay, we had this accident last year, but they've never done anything. They haven't sued me or anything. To be on the safe side, you list them. Because if after the bankruptcy's over, then they get served with papers, you got to go back and reopen the case to add that creditor. So it's best to make sure that the client puts down on their petition all their creditors, credit cards, doctor bills, and anyone who might think that your client owes them money, even if they're wrong. Okay, so that's who we list as creditors. The trustee, obviously. In a Chapter 7, the trustee is the liquidator and is not there to help you resolve your disputes with your creditor. The trustee's job is to take stuff they can from you and pay something to the creditors. That's it. The U.S. Trustee's Office. The Trustee's Office is the office that oversees the trustees. The U.S. Trustee's Office is a department of is a branch of the Department of Justice, and the responsibilities include monitoring the administration of bankruptcy cases, detecting bankruptcy fraud, and it's also responsible for appointing and supervising the Chapter 7 and Chapter 13 trustees. These days, the majority of the work that the U.S. Trustee's Office does is the means tester. And they spend most of their day looking at the new cases to see if that case is properly filed as a Chapter 7 under the means test, or if it really should be a Chapter 13. That's mostly what they do these days. The judge. Judge is judge. What more do I need to say? Nothing more right now on that. The clerk. The clerk obviously is kind of like a clerk in any old court, except the bankruptcy courts are now paperless. If you are an attorney and you practice in the bankruptcy court, they will not allow you to bring paper. You have to do everything electronically, which is really good. It's a nice system. It really is. I like it a lot better than carrying my box every Friday with hundreds of pages of bankruptcy petition. All right, so how long does a Chapter 7 case last? These are general timelines and they vary a bit. Also, let me show you something here. On the lower right-hand corner of the slide, you will see a page number. That corresponds to the page in the written materials where you'll find more details on what we're talking about. Also, you may see appendix page, certain page. That is a form in the appendix that that corresponds to what we're going to be talking about. All right, so the timeline. From the time that we file, the creditors meeting of the creditors, the 341 meeting, happens about 30 days after the case is filed. Now, the reason they call it the meeting of the creditors is that the code provides for the creditors to be able to come in and ask questions of the debtor when they file a bankruptcy. Most of the time, they don't. It's kind of a waste of time these days. Usually, if they do, it's because it's convenient to them. It used to be, like, for example, in Orlando, the bankruptcy court was in a bank building. The only people we would ever see there would be the bankruptcy representative from that bank, because it was one floor down from where her office was. But most of the time, the creditors they would much prefer dealing by mail and by email. So really, the creditors meeting these days is the trustees meeting. It's the point where the trustee can ask some questions. We will go into that in a little bit greater detail. The objection deadline that creditors have to file objections is 2 months, 60 days after the creditors meeting. The initial creditors meeting date is set. So if a creditor feels that they have been wrongfully dealt with, if they have been defrauded, or if they have a legal reason to file an objection to the bankruptcy, they have to do it 60 days after the creditors meeting, or they lose their shot. Okay. The discharge can happen any point after that objection deadline. So the objection deadline in the case is the earliest time, actually the day after, is the earliest time that the judge could actually sign the discharge. And the case can close in a no asset case any time after the discharge. And in the Orlando division, I mean, that can be the very next day. We see cases closing quickly. In asset cases, so if the trustee has collected some money and the trustee has to divide up the money and send it to different creditors, that takes some time. They have to send out notices. The creditors get an opportunity to send back their proof of claim, and the trustee goes through their procedure of liquidation and getting court approval for distributing the money. That takes, gosh, some cases that can take years. Usually it doesn't. Usually it will take less than a year. The case stays open, but the discharge is probably still going to happen 60 days after the creditors meeting, unless the trustee thinks that there's a reason not to grant the discharge, and they can extend it. One of the first things that happens when a case is filed is the notices go out. And in the materials, well, actually it's not in the materials, on the screen here, the first thing you'll get is the notice of the 341 meeting. But this first notice that goes out has a lot of information on it, and including, let's see here, who the attorney is and who the bankruptcy trustee is, when the meeting of the creditors is, okay. Let's see here. If there was a presumption of abuse, now in this particular case, there was a presumption of abuse. So, and what that means is that whenever you see this, that means the U.S. Trustee's Office is going to really be looking very, very carefully at it. Deadline to file a proof of claim. This also goes to creditors. So they know that in this case, February 4th, 2013 was their deadline. The federal government, actually governments in general, have 180 days to file. They get twice as much time. And let's see, the deadline to object to a discharge or to challenge dischargeability on certain debts was going to be January 5th of 2013. So this is a notice to the creditors. Okay, folks, bankruptcy is being filed. If you want to file an objection, you have until January 5th, 2013. If you take longer than that, too late, you're out of luck unless you come and ask for permission. So this is the first thing that goes out to creditors. And it usually takes about 10 days about 10 days from the time the case is filed for these things to be mailed out. And they're mailed out of a huge mailing facility, at least on this part of the country, from Baltimore. Now, I don't know if the West Coast has a different one, but all of ours seem to be coming out of Baltimore. All right, the next section that we're going to be talking about is the means test. And how to handle the means test, how to set up for the means test. The idea here is that the U.S. Trustee's Office wants to make sure that only people who should be filing a Chapter 7 are filing a Chapter 7. And so we have to put together the information for a 6 to 8 page form that tells the trustee whether or not the person passes the mean test yet. So what we have to do is we have to determine what the debtor's income is. Sometimes that's tricky. Take the standardized and actual expenses, and we'll talk about some common mistakes. And then actually later on, my assistant Peggy and I are going to be going through it line by line on the program that I use just to show you the difference that the details can make. Okay, so how do we determine our debtor's income? All right, well, the easy way is pay stubs. Okay, a person comes in and they show you the pay stubs. Well, you have to ask them as part of your pre-bankruptcy questionnaires here. Okay, do you work? How many jobs do you have? Do you have any other sources of income? And so that comes into it. So we look at the pay stubs, we look at their taxes. If they're self-employed, it becomes a little trickier. If they're self-employed, if they're 1099 employees, then usually there'll be something from wherever they get their money from that they can show you. We can look at monthly income, average income, like realtors. Realtors are a little tricky because they may have a closing 1 month and not have another closing for a couple months. Well, under those circumstances, we take an average of what their income is in the last 6 months. But if someone is operating their own business, like they have a tree trimming service or some other service, if they have a CPA or accountant that has monthly reports, income and expense reports, we want to get a copy of those. Because the important thing about this is that we don't want to mischaracterize their income. If they're earning $10,000 a month, okay, then that's what it is. But we want to make sure that they're not actually earning $4,000 a month when the paperwork looks like it's 10. Sometimes they don't have CPAs or accountants. Under those circumstances, we can take a look at the deposit slips. Now, just about everybody these days has electronic banking, and they can go on and you can run a report about all of their deposits that go into the bank. Sometimes people will have businesses and they don't do a really good job of separating the business income from the personal income. And sometimes the business will pay for the light bill, or the business will pay for the mortgage bill, or something like that. So our list for the self-employed person includes personal expenses that have been paid for by their business. That goes down as income. Yeah, and also their tax returns are sometimes helpful. In fact, depending upon the type of business they have, their tax returns may have, I guess, a profit and loss statement included in it, and business value. Once we have determined what their income is, then we pull out the chart. In appendix page 4, I have a full version of this, but it's an older one. This is current. I pulled this down yesterday. After April 1st, 2014, the way that this works is, and you can find this chart at the Department of Justice website and most clerks' offices, you can look up your state by, you have the state, you have one person, two people, three people, four people, however many people are in the family, and this is what their gross income, not their adjusted gross income, but what their gross income is. If they have more than 4, then you add an additional $8,100 for each individual. So this is kind of the first glance. So if I have a family of 4 and they're earning $70,000, well, technically that's over the means test on this chart. But that doesn't mean that it's over, because we can go into more itemized things. There are things that can have an effect, like how many cars they have. Do they have mortgage payments? Do they have business expenses that they have to pay? So, but this is the first look. If you're looking at this chart here, family of 4, and the family earns, the household income is $100,000, that's pretty much going to be a Chapter 13. Not much you're going to be able to do about that, probably. But that's the first blush. But that by no means is the end of the story. So, also, does the debtor qualify based upon income? So we looked at that chart. Okay. Now, if most of their debt is business-related debt, not consumer. Consumer would be their mortgage, their car, their credit cards, even their doctor bill. But if they own a couple of pieces of rental income property, or if they own a business and they had to co-sign the loan on that, then that's business related. And if over half of their debt is business related, then they don't have to, the means test doesn't really count for them. I mean, you still have to do it. You can't get you have to file it. But as part of checking off the boxes on your bankruptcy petition, you would classify the case as a business related case. Now, there are some cases where even if it is a business-related case, or even if they're below the means test on that chart, in a 707 case, the trustee, if they determine that the person has so much money left at the end of the month that they could easily afford to do a Chapter 13, then they really should do a Chapter 13. Again, this is part of what the trustee does most of the day, the U.S. trustee. And the code section, 11 U.S.C. 707 B2A, is fairly long and confusing. And so the synopsis is, my translation of this is that if a debtor's monthly disposable income, the surplus income, times 60, which is the length of a 5-year Chapter 13 plan, is at least 25% of the unsecured debt, or $6,000, whichever is greater, or $10,000, I don't quite get that part, they can be forced to file a Chapter 13, or the case would be dismissed. Parts of this law were written in haste, and some of the information doesn't flow. But the 25% rule is really a pretty good one. So if you look at the money that your client has left over at the end of the month, you're looking at your income and the monthly income and their monthly expenses, and they have $1,000 left over at the end of the month, and you multiply that by 60 months, and if $60,000 is greater than 25% of their unsecured debt, then the trustee is going to probably want them to file a Chapter 13 so that they can take some of that surplus income and pay it to the creditors. The idea of a Chapter 13 is that it's supposed to be affordable, and it's affordable based on their actual income and their actual allowable expenses. So if it is not affordable, then they're not supposed to file a 13 and they're supposed to file a 7. So that's what the means test analysis is. But this is kind of confusing, but the 25% rule really is a pretty good rule of thumb. Okay, what happens at the creditors meeting? And like I said, it should be called the trustees meeting. There is it's a time when the bankruptcy trustee can ask questions. The first thing that happens is you go in and your client is sworn in. Do you solemnly swear that your information will be true and correct to the best of your knowledge? Swear or affirm is the way that they do it. And let's see, that's 34, trustees checklist. Let me skip forward here. And a lot of times what the trustee will do is ask the individual to fill out an additional form. I have it, one of the forms here under number 34. The first thing they do is they do swear you in. And the reason for that is that there has to be a verification that there was an actual person who filed the petition, that they ask for a copy of a photo ID, a proper ID. Some trustees will not accept, they're not supposed to accept expired IDs, and proof of Social Security. That can be the Social Security card, that can be a W-2, that can be something from another government agency, or something that's not created by the debtor. Okay, so the debtor's own tax refunds won't do it. Um, they will ask if all of the creditors are listed, all of the assets are listed, and then they'll get into some of the specifics about the information that is on is on the petition. Where did you get the value of that car? How many miles does it have on it? They require that you put the VIN number down because a trustee can look up and find out anything they need to know about a vehicle by the VIN number. It's at time that they will ask about the exemptions. Sometimes the trustee will ask, okay, well, Mr. Bolves, why did you claim this exemption on this piece of property? So a lot of stuff gets done. They really should call it the trustees meeting because it's the trustees' opportunity, really the only opportunity to meet with everybody involved. It is open to the public, and when you go into a creditors meeting, it'll be you, your client, and probably a bunch of other attorneys and a bunch of other clients. And I usually tell people to show up a little bit early so that they can listen to how they go, because it's the same question over and over again, pretty much all day long. All right, so the trustee administers the oath or affirmation, and so a good thing to do would be appendix number 34. Take a look at this, and in fact, this is good to know when you're preparing the petition, and we will go into that because some of the questions here you need to know the answers already. Are they personally familiar with the contents of the bankruptcy petition? Did they read the petition before the case was filed? Did they read all 60 pages of the petition before the case was filed? That is a question. Did they read the worksheet that describes the kinds of bankruptcies that there are available? Have you ever filed bankruptcy before? Because you can't file bankruptcies without limit. There's some timing involved if you have to file more than one. Are you ordered to pay alimony, maintenance, or child support? And the reason they ask that is because the trustee has a requirement of giving notice to the individual. So if your client is paying child support to his ex-wife, if the trustee collects any money in that case, that is a priority claim. And that's actually the highest priority claim, and the trustee has to pay some money. So that should actually be in their in the petition. Let's see here. What's another good one? Tax refunds. That's a big one. If at the time of year that the case is filed, your client is owed a tax refund by the IRS, that refund most of the time is going to be the property of the bankruptcy estate. The only exemption to that would be if most of the refund is for earned income child tax credits. And there's a very specific part of the tax return that you have to look at for that. We're not just talking the normal deductions that you get for having kids. It's lower on the page where it's actually money that your client gets from the government because they have the children, not as a refund of any taxes that they have paid. So the trustee can't have that amount, but it is most of the time a regular old refund is something that the bankruptcy trustee can get, and that's either in a Chapter 7 or a Chapter 13. And let's see here. Are there any changes or amendments that need to be made before they get started? Have you sold, traded, or given away any property in the last 2 years, including any foreclosed property or repossessed items? And the reason for that is the trustee is looking for transfers, something that might be voidable. We'll be talking about the powers of the trustee. They really can do a lot. What I tell clients is that the trustee can undo just about anything you have done in the last 2 years under the right circumstances, or for their case, under the wrong circumstances. So I need to know, what transfers have taken place. Did they sell their car? Did they give something away? Is their name on any other property? How does all that work? Do they have any lawsuits? Whether they're being sued or if they're suing somebody else, because a lawsuit can be an asset. If your client is the plaintiff in a case, where they may end up with $200,000, $300,000, that's an asset. That's an asset that the bankruptcy trustee, at least on the pain and suffering section, this varies somewhat from state to state, but the trustee could could basically take over the case and settle it. And the trustee does not have to settle it for its full value. The trustee can jump into the case, give a call to the attorney who's handling the personal injury case for your client and say, hey, let's settle this thing. Let's finish it up. So yeah, that becomes property of the estate. Have you inherited anything recently? Are there still, for example, if you have a client who their father passed away a year ago, and the probate hasn't quite closed yet, or there might be some inheritances that are still being worked on, like the sale of a property, that's something that the trustee can get and sell to, disperse to creditors. Okay. Also, if there's an inheritance within the 6 months after the case is filed, even after the case is closed, that is still considered part of the bankruptcy estate, and the trustee can get it. All right, the next section that we're going to be dealing with is specifically Chapter 13 cases. We'll be talking about the definition of a 13, what it is, the parties involved, the timelines, how to put together a plan, what a plan really is, and also we'll talk about some motions, additional relief available in the case. And that's becoming more and more. There's a lot more stuff out there these days than there used to be. Okay, the definition. Chapter 13 is a reorganization of debt by which the debtor proposes a plan that pays all priority debt. It must pay priority debt, which, and you can choose which secured creditors will be paid, and pays whatever else is able to be paid to unsecured creditors. So must pay priority debt, choose which secured creditors they will pay, and pay what they are able to unsecured creditors. The maximum time that we have for a Chapter 13 plan is 60 months. Any longer than that, and we have to go into a Chapter 11 case. So who's in this? We have the debtors, obviously your clients. The trustee is a different type of trustee. The trustee in this case is not a liquidator. They do have some ability to liquidate things, but that doesn't happen very often. The trustee is the facilitator of the plan. And we will be going over in a little bit more detail what the specific role of the Chapter 13 trustee is. But basically, a 13 trustee checks over the plan, makes sure it's going to work, receives the payment from the client, and makes the payments out to the creditors according to a confirmed plan. The creditors obviously are anyone who money or a claim is owed to. And in a 13, they have to file a proof of claim and prove that they have a claim. That's why they call it a proof of claim. And that doesn't always happen. For example, if you have somebody who claims that they are owed money and they don't have any documentation that they can prove it with, and they claim that they have a lien against somebody's car but don't have a documentation for it, then they may not be able to prove that they are a secured creditor. So the whole proof of claim process is so that the trustee can figure out who they need to pay and how much. The court, obviously, the judge will ultimately approve a confirmed plan. And the idea of the confirmation hearing is that this is when all the parties can get together. It rarely happens quite this way, but this is when all the parties get together and it is finally decided that you have a confirmable plan, and this is what the terms are, and these are what the payments are going to be. You know, usually on a case, all of that is taken care of well in advance of the actual confirmation. You can amend a plan as many times as you need to before the confirmation, and that sometimes happens. We'll get into the details of that in a little bit. But ultimately, the judge is going to, at the confirmation hearing, figure out or approve a plan, or if the plan can be approved. Sometimes they can't, and it doesn't go forward. But once it is, then that's kind of the rule of the road. Your clients have to pay the same amount every month, and the creditors have to sit back, and they don't have to. They can't charge late fees. They can't make any demands on your client because they're not getting paid when they think they should. It's pretty much up to the confirmation order to decide, and also the trustees have something to do with that too, as to when they actually get paid. Clerk of the court, same basic deal as before. They process and get the file prepared. You file the motions, they respond to it, they send out notices, all the things that a clerk would normally do. And the U.S. Trustee's Office has less of a role, really, in Chapter 13 cases. They do conduct oversight over the over the Chapter 13 trustee. They will occasionally come in and audit the books, quite frequently, actually. And so theirs is more of an oversight capacity. They get involved much less in 13s than they do in 7s. All right, so let's talk about what happens in an average, what the timeline is in an average Chapter 13. Okay, well, from the time the case is filed, your plan must be filed within 15 days of the case being filed. I try to do them on the same day. Sometimes it doesn't work out that way, where you got to get a case filed to prevent a foreclosure from going through, and then you take the additional week to get the plan in. But it has to be filed in 15 days. If it is not, generally a motion to dismiss is either filed, or in some places it's just dismissed. If you don't file your pleadings on time or your requirements, they can pretty much just kick you out pretty quickly. That varies from district to district. At least in our district, the clerks are nice and the trustee's nice, and if they see it's day 16 and they don't have a plan, they might send you an email. You cannot rely upon them to do that. In all cases, you must assume the angry trustee or the angry clerk. Okay, so that's going to require you to do things according to the book. If you do everything by the book all the time, you won't have a problem with anybody, really. The meeting of the creditors, that can vary a lot. The 341 meeting, that can happen anywhere between 21 and 60 days out, depending upon the area that you're in. It's kind of rare that they happen in 21 days, because you barely have a chance to get the notices out for that. But in some places they do it. So at the creditors meeting, I think we'll be talking about that in a little bit. Yes, we will. Okay. The first plan payment varies by the local rules. In our district, the first payment under the bankruptcy plan has to be made to the trustee 30 days after the case is filed. So if you file it on the first of one month, then your payment date is pretty much always going to be the first of the next month. And even though we don't have a confirmed plan yet, we have to start making payments in what we believe our plan is going to be. And that way, secured creditors like mortgage companies and car companies can't say, hey, that's no fair. We're not getting any payments, and the person filing the bankruptcy hasn't made any payments either. Well, as long as they're making payments to the trustee, they're adequately protected. Okay, even though the trustee hasn't sent the money yet, as long as your clients are following their requirements by making their plans accordingly, then the creditors have to stand back and let the process flow. Now, the confirmation hearing, one of the changes in the law in 2005 was that the confirmation hearing had to happen really fast. It doesn't There's no way you can have a really fast confirmation hearing. In fact, it called for the confirmation hearing being before the proof of creditors, the proof of creditors deadline, proof of claim deadline. And so how do you do that? Well, so what a lot of districts have done is that they have two dates. They have the official confirmation date. They call it the initial confirmation hearing, at which time they expect nothing will happen. Because there's really, unless it's an incredibly simple case, generally things are not going to get confirmed because you need more time than 20 to 45 days after the case is filed. There's just not enough time. Actually, I misread that. It's 20 to 45 days after the creditors meeting. Usually, the real confirmation hearing will take place after the proof of claim deadlines, and that's going to be normally 5 or 6 months out, and that gives enough time for all the creditors to get their proof of claims in, for the debtors council to take a look at them to see if any of them need to be objected to file any motions that have to do with like valuing property, or a motion for modification mediation, which is happening in Florida and some other areas. We'll chat about that a little bit. It's really pretty cool. So a lot really has to happen before a final confirmation hearing and a final confirmation order can be entered. It saves a lot of time if you take a little time, because if the confirmation orders had to be entered 30 days after the case is filed, there would be so many motions to amend a confirmed plan due to things that would happen afterwards. It would simply take up too much time. So the way that the courts, or most courts, are handling the confirmations is they'll have an initial confirmation hearing at which they will expect nothing will happen, and then they will continue the confirmation date to a later date a couple months down the line, at which time everything really does happen. And I strongly suggest that when the final confirmation hearing happens, that everything be done, because you really do have enough time. You really have enough time to get everything done by that point for it to move forward, unless you have extenuating circumstances. And if you do, communicate with the trustee, because at these confirmation hearings, it will be the judge, you, and the trustee or the trustee's representative standing right next to you. The judges generally do not read these files before the confirmation hearing because there are just so many of them. The motion always is, they call your hearing, the judge looks to the trustee who gives a synopsis of what's happening in the case. So if the trustee doesn't know what's going on with your client and why you're not ready to confirm, then then it's not good. A lot of judges are annoyed when confirmation hearings don't happen. And in fact, it was so rampant at one point that our chief judge, now Judge Gentleman, started taking fees away from attorneys for not having the case ready if it didn't look like there was something, a reasonable reason not. So if you didn't have your file ready, it could be that the trustee would take away $500 worth of fees, or the trustee, the motion, the trustee could file a motion to take some of that money away from you because it hasn't been earned. So it's a real good idea that when you get a notice of the confirmation, that you take the steps necessary to make sure that it does get confirmed, or that you talk to the trustee so that they know what's going on. The proof of claim deadline in a Chapter 13 is 90 days after the creditors meeting, okay, the 341 meeting. And so that usually ends up being 4 months, and that's generally enough time for the creditors to get all their stuff in there. Sometimes they don't, and sometimes you have to file a proof of claim on behalf of a creditor because they're not in there. And that's important sometimes when you have secured creditors. If you want a secured creditor to be handled a certain way in the plan and there's no proof of claim, that could prevent the confirmation hearing from happening. So sometimes what you do is you file for them a proof of claim, and if they want to come back and amend it, they can. But at least, obviously, if you're filing a proof of claim for like a second mortgage company, you use the information that you can. You just stick it in there, you file it, it's there, and then you proceed. The whole idea about a 13 is that the case flows. The judges don't like it when the cases get clogged up or basically stop at the time of confirmation, because a lot of times, well, like our judges here will only give you one continuance from the final confirmation, and you got to have a really good reason for that. And if it's going to take longer than that, you got to have a really good reason for that, or they'll just dismiss the case. Because if you don't come to court ready to play, don't expect anyone else in the room is going to want to play with you. The discharge happens at the end of a successful plan. So we're talking 60 months, 5 years away. So after all the payments are made according to the plan and the trustee sends in their notice that the payments have in fact been made according to the plan, then the discharge will be entered. Now sometimes there are reasons that you can get out of a plan early. For example, I had a case not too long ago where the people were 6 months short of the end of their plan. And I believe what happened was that there was some major surgery that that either the husband or the wife had to have, and it really affected their income, and they had paid the majority of the money that they needed to pay in the plan. And under the circumstances, I filed a motion for a hardship discharge, and it was granted. The judge says, okay, well, obviously you have done the best that you can, and under your circumstances, you're not going to be able to continue with the regular payments here on out. I'm going to declare you've done the best that you can, send the case, give you your discharge, and that's it. And the case was done in less than 60 months. Normally, however, the only time where you can file a plan that's going to get rid of, basically conclude a case in less than 60 months is if it completely pays all the unsecured creditors, all the credit cards and doctor bills, things like that. Otherwise, it has to be a 60-month plan. So after the conclusion of the payments, the trustee will file their final report with the court asking for approval. After it is approved, then it is closed. All right, so what is the goal of a Chapter 13 plan? All right, it is personal reorganization, obviously. In a plan, when we're putting it together, we have to get caught up with secured creditors, all right, and the debtor has to pay what they can afford to unsecured creditors to protect their assets, if that's an issue, to eliminate second mortgages and other liens. You can sometimes value vehicles, and most of the time it's a 60-month plan. So let's take a couple of these here. Protection of assets. Let's say a person would normally be a Chapter 7 case. Their income is under the means test, not a problem, and but they have a piece of property. Let's say they own a lot on the side of a lake someplace, and they want to keep it, and that lot is worth $10,000. Well, and they don't have $10,000 because as soon as you go in to the creditors meeting on a Chapter 7, the trustee is going to say, well, in exchange for me getting rid of all this other debt, you got this $10,000 unprotected asset. You either need to give it to me so I can sell it and pay money to the creditors, or you need to give me $10,000. Well, if the person doesn't have $10,000 and rich Uncle Fred doesn't want to give them a loan, what they can do is they can file a Chapter 13 and they can keep the property. as long as they pay at least $10,000 to their unsecured creditors. That's the trade-off there. So they're going to end up paying $10,000, okay? And in a Chapter 7 situation, they have to pay it all at once. Trustees will give you, in a 7, they will give you an opportunity to make a payment plan, but generally not very long. In our area, 10 to 12 months is the norm. Every once in a great while, I see a trustee allow it to go to 18 months. Sometimes that involves tax refunds, though. I think that's the reason they do it. And even that could be a big payment. So if you're going a 10-month plan on a $10,000 asset with a Chapter 7 trustee, the payments are going to be $1,000 a month. That's just too high. So instead, you may find a person who wants to protect their property by filing a Chapter 13 plan, whereby they can pay this amount over the life of the Chapter 13 plan. Okay, it could be $10,000 divided by 60 months. So that's a little easier to handle rather than divided by 10 months. Generally speaking, in a Chapter 13, you can protect whatever assets you want to as long as you pay the amount of your non-exempt assets through the plan to the trustee. Stripped on a second mortgage. This is now, well, it's been available for a while in a Chapter 13 and is now available in a 7-2, but there's some hesitancy there because there's some still cases on appeal where if they go the wrong way, we may not be able to do that for much longer in a 7. However, in a Chapter 13, the idea is that if you have two mortgages and the first mortgage balance is greater than the value of the house, then the second mortgage has no equity covering it. So really, even though they have a lien, the lien has no value, because if the house did go to foreclosure, they would get wiped out because there's no equity. So under the circumstances, what we are allowed to do is file a motion to strip where we prove what the value of the property is, prove that the amount of the first mortgage is greater than the value, and prove that the second mortgage really doesn't have any equity on it, and convince the judge that that second mortgage or third mortgage really should be treated as if it were a credit card. So let's put it in the basket with the credit cards and doctor bills and things like that, where they get leftovers, very small amounts. And as long as the debtors take the case all the way to the end and they successfully pay all 60 months, at the end of that 60 months, they get an order which eliminates the second mortgage. It strips it. After which time it's a good idea to record that in the county records. So that's a nice thing that we can do in a Chapter 13. Also, value property. If there's any property that has some collateral, or actually property that is collateral for a secured creditor, such as cars or even rental income properties, and as we were kind of talking earlier, what we can do on this is that let's take the car example again. The car is really worth $10,000 and the lien on it is $20,000. We can value it, get an appraisal, file our motion, prove up that the value is actually $10,000, and then what we do is we pay that $10,000 over the life of the Chapter 13 plan. Okay. I have some clients that were doing that very same thing with an entire house. It's a rental income property, and it's not worth a whole heck of a lot. And we did some calculation. Yes, we figured out how much money they're getting in rent and how much the property was actually worth. And if we do a motion to value and ask the judge that we can pay the value of the house out over the life of the plan, the amount that they're receiving in rent is greater than the amount that the clients will be paying into the plan for that. So for them, it really worked. So, that way, at the end of the 5-year period, that rental income property is going to be paid off free and clear. So that's a pretty good deal. It's like zero interest financing on property. A lot of times you don't see that happening because the value has to be within a range that that people can actually afford. Now, if this was $1 million house, that, you know, 1,000,000 divided by 60 is still a lot of money, and probably, you know, the people would probably not be able to do it. Okay, and the plans again have to be at least in a Chapter 13, no greater than 60 months. The creditors meeting at a Chapter 13 is really quite a bit different because the trustee is not sitting there looking for stuff. The trustee is there to, well, a couple of basic stuff. You know, you've got to administer the oath or affirmation. Ask the same stuff as in a Chapter 7. Ask that ask if the debtors have provided all of the information to the best of their ability. Ask if they have listed all of their creditors and all of their assets. And from that point on, the trustee is looking for information relating to processing the plan. And often what will happen is that the trustee or the trustee's representative will take the opportunity to mention a couple things. They'll say, oh, their calculations were $10 difference, or, you know, their liquidity was short, or this should be 100% plan, or basically little tweaks. Sometimes if it's obvious that something should be filed, or an amendment should be filed because something is in the wrong place, or it's more housekeeping. The creditors meetings in a Chapter 13 are usually a little bit shorter. Now, creditors can show up, parties in interest can show up and ask questions, but they are much less likely to in a Chapter 13 as they are in a Chapter 7, because Chapter 13s have it's tougher to object to a Chapter 13. And the objections that you do see are simply normally matters of something being listed incorrectly. Like I will get an objection from a mortgage company in a Chapter 13. And that objection usually is, on the petition it said that $95,000 was owed, when in fact $96,132.57 are owed. Okay, that's easy to fix. Or that the payment amount on the plan was $723 when it's actually $801. Okay, well, we can fix that too. It's usually little tweaks, things along those lines. Every once in a while, it's something a little more major, like at least in the state of Florida, credit unions like to cross-collateralize all of their loans. So if you owe a car loan and you also have a personal loan with them, chances are it's all tied up in the same collateral, or a credit card also. And they may object based on the fact that all of their collateral is not included. And then you would have to respond to it. But that's part of the whole process leading up to the confirmation, at which point everything settles down into a plan that the court is going to be able to approve. And again, they call it the creditors meeting, but it should be called the trustees meeting, because that's really, it's the trustee who gets the most use out of it. All right, the Chapter 13 discharge is a lot different from the Chapter 7. There are debts that are dischargeable in a Chapter 13 that are not dischargeable in a 7. For example, debts for willful and malicious injury to property as opposed to the person. So, for example, if I go and beat up your car with a hammer and file a Chapter 7, in a Chapter 7, I can't get out of the debt because it was an intentional willful act. In a Chapter 13, I may be able to. You may be able to get me to pay some money in a Chapter 13, but it is somewhat dischargeable. The difference would be bodily injury. That's not dischargeable in either case. Debts incurred to pay non-dischargeable tax obligations. Non-dischargeable tax obligations. Okay, let's see. All right, I'm sorry. I was thinking of a recent case here. In a Chapter 7, there you can get rid of income tax debts that are over 3 years old, and that's based on when the taxes were filed. Anything less than that, well, if they're more than 3 years old, then they are dischargeable. Anything less than that, they are not dischargeable. In a Chapter 13, they're handled a little bit differently. Certain types of tax debts, as long as they're paid in the plan or partially in the plan, may be dischargeable. Debts arising from property settlements and divorce and separation proceedings. In a Chapter 7, whatever the divorce judge says, the bankruptcy judge is not going to mess with. So if the divorce judge said in a property settlement agreement that you, husband, have to pay for the credit cards of wife, even though you never signed them, then the Chapter 7 judge is not going to let that obligation to the ex-wife be dischargeable. It's a little bit different in Chapter 13. In a Chapter 13, the only things that are not dischargeable along those lines from domestic relations issues are alimony and child support. Those are priority debts. Those are the top priority debts. Those have to be paid right along with the taxes, even before secured creditors do. But the other portion of it, the amounts that are due for property settlement, property division, debt division, those would be considered unsecured, and they would receive something in the plan, but at the end of that plan, that would be dischargeable in a 13, whereas they would not be dischargeable in a Chapter 7.
If you'd like any additional information on bankruptcy, please don't hesitate to give me a call at my office at 407-894-1002 and check out the website, thelegalcenter.com.